Good day, everyone. Welcome to the event hosted by Contrast, ICOHI and AFAD. My name is Adelwin Airo Anwar. I am part of the Contrast International Advocacy Division. Today, I will serve as moderator for today's webinar. So in today's webinar, we will bring attempt ratification of the International Convention for the Protection of All Persons from Enforced Disappearance, or ICPPED, lesson learned from the ratification for Indonesia. So, conventions are one of the instruments of the international law that have an extraordinary impact on state parties. However, before the convention is legally binding, the state must ratify it. After the state submits to the convention, the state must harmonize it into national legislation. One of the crucial conventions to protect the human rights of its citizens is the ICPPED. ICPPED is an international human rights instrument of the United Nations and intended to prevent enforced disappearance defined in international law. It's crimes against humanity. To date, Indonesia has not ratified the ICCPED, despite the encouragement from several countries during the Universal Periodic Review session to immediately ratify the convention. This encouragement is based on heinous practice that occurred during the New Order era and can happen again in the future. Otherwise, the existence of a legal instrument to prevent the recurrence of this event is necessary to provide. As we know that the Ministry of Law and Human Rights said that Indonesia is targeting the ratification of ICPPED to be completed and ratified by the Indonesian House of Representatives before the commemoration of World Human Rights Day on 10 December 2021. The Coordinating Ministry for Political, Legal, and Security Affairs has issued a letter recommendation to appoint the Ministry of Law and Human Rights to initiate the process of ratification of the ICCPED. The need to immediately ratify this convention is a preventive and corrective function that state must carry out. However, we want to ensure that the ratification of ICPPED is not just a euphoria without being translated into quality nation. So, in discussing this matter further, we will discuss it together with three speakers who understand the problem. Our first speaker is Miss Fiora Preti. She is the head of Impunity Watch Division at the Commission of the Disappeared and Victims of Violence Contrast Indonesia. She will give us a brief explanation about the practice of enforced disappearance in Indonesia, the update advocacy of ICPPED ratification in Indonesia, and further steps that in advocating the ratification of the convention. Our second speaker is Ms. Visnavi Managaran. She is part of families of the disappeared FOD Sri Lanka. She will give us the explanations about benefits of ICPPED after ratification for Sri Lanka, and legal and or political challenges and obstacles that arose in Sri Lanka after the ratification that prevented the full realization of ICPPED. And our last speaker is Ms. Milicia Kolakovic-Bojovic. She is Vice President of United Nations Committee of Enforced Disappearance. She will give us legal and or political challenges and obstacles in state parties after the ratification that prevented the full realization of ICPPED, and best practices from civil societies in monitoring the implementation of ICPPED after ratification by the state parties that Committee of Enforced Disappearance accounted. So for those of you who want to ask questions, you can ask questions in the YouTube comment section. So without further ado, let's welcome our first speaker, Ms. Preti. The floor is yours.
Hai, terima kasih Adelwin dan selamat sore kepada teman-teman sekalian. terima kasih yang sudah ikut bergabung bersama kami dalam webinar ini. Mungkin sebelum saya memulai pembicaraan diskusi ini, sebelumnya saya mau mengucapkan juga selamat datang, salam hormat, dan salam dari Jakarta kepada Miss Milika dan juga Miss Nafi. Terima kasih karena telah mau bergabung di sini dan berbagi pengalaman dengan kami di Indonesia. Salam sehat, semoga dimanapun kalian berada, kalian tetap dalam keadaan sehat. Mungkin saya akan mulai dari penjelasan tentang penghilangan paksa di Indonesia. Uh, Sebenarnya penghilangan paksa itu adalah suatu tindak pidana yang dimanapun berada, bukan cuma di Indonesia tapi di negara lain juga seperti gunung es. Jadi yang kita ketahui jumlahnya itu hanya sedikit saja, hanya ujungnya saja yang kelihatan, tapi sebenarnya lebih banyak yang kita tidak tahu karena mungkin tidak dilaporkan, juga keluarga mengalami intimidasi sehingga tidak mau melaporkan dan sebagainya. Di Indonesia sendiri kita mulai mendata dalam Komnas HAM itu penghilangan paksa dimulai dari tahun 1965 ketika Orde Baru dimulai gitu. Nah, masa otoriter di Indonesia itu terjadi ketika era Soeharto, yaitu selama 32 tahun dari tahun 65 sampai dengan tahun 1998. Jika ditotal jumlahnya dari 65 sampai dengan 98, kira-kira yang bisa kita setidaknya yang tercatat itu ada sekitar 50 ribuan lebih penghilangan paksa gitu. Tapi pun ketika Orde Baru dan saat masa otoriter itu penghilangan paksa digunakan sebagai alat bagi pemerintah untuk menghilangkan suara-suara yang vokal, yang kritis terhadap pemerintah, yang menolak pemerintah, baik menolak kebijakan atau pernyataan pemerintah. Bahkan bagi seniman yang melakukan kritik melalui seni mereka, misalnya melalui puisi dan sebagainya, mereka juga menjadi target yang dihilangkan secara paksa. Begitu juga ketika kita tahu di tahun 89-84 penghilangan paksa itu juga dilakukan terhadap komunitas-komunitas agama, yaitu di Talangsari dan juga di Tanjung Priok itu dilakukan terhadap jemaah Muslim di sana. Juga penghilangan paksa terjadi ketika kita Indonesia saat itu ketika Timor Leste ketika Timor Timur saat itu menjadi bagian dari Indonesia. Sebelum kemudian akhirnya Timor Timur berpisah dengan Indonesia, ada begitu banyak penghilangan paksa yang terjadi di Timor Timur, dan juga ada anak-anak yang diambil oleh orang-orang tidak bertanggung jawab dari aparat Indonesia saat itu, dan anak-anak ini kemudian dibawa ke Indonesia tanpa dokumen adopsi yang sah, tanpa pengetahuan keluarga mereka di Timor Timur, dan ada banyak juga jumlahnya, dan itu biasanya di Indonesia juga kita sebut sebagai stolen children, anak-anak yang dicuri. Selain itu juga penghilangan paksa juga terjadi bukan hanya dilakukan oleh pemerintah, tapi juga dilakukan oleh kelompok-kelompok separatis di Indonesia. Itu pernah terjadi juga di peristiwa di Aceh. Jadi pelakunya bukan hanya pemerintah, tapi juga bisa kelompok-kelompok lain, atau dalam peristiwa 65 ketika itu banyak juga masyarakat yang kemudian dengan di-backup oleh negara gitu ya, melakukan penghilangan paksa kepada orang-orang yang saat itu dituduh sebagai komunis gitu. Nah, walaupun rezim otoriter ini sudah berakhir di tahun 98, tapi sebenarnya Indonesia belum pernah punya punya satu peraturan khusus tentang penghilangan paksa. Penghilangan paksa di Indonesia paling hanya diatur dalam Undang-Undang Pengadilan HAM yang mana mengatur penghilangan paksa sebagai bagian dari crimes against humanity. Tapi tentu saja crimes against humanity mempunyai unsur seperti sistematis dan meluas, yang mana tidak semua penghilangan paksa dapat memenuhi unsur itu, dan Indonesia tidak punya peraturan mengenai penghilangan paksa di luar daripada crimes against humanity. Akibatnya ketika ada kasus-kasus penghilangan paksa di luar dari crimes against humanity, maka aparat penegak hukum Indonesia akan memasukkannya ke dalam pasal penculikan biasa, yang mana tentu saja penculikan berbeda karakteristiknya dan juga kengeriannya daripada yang dimaksudkan dalam unsur-unsur penghilangan paksa. Nah, karena kita tidak pernah punya peraturan mengenai penghilangan paksa, Indonesia tidak pernah punya peraturan mengenai penghilangan paksa, jadi walaupun tahun 98 sudah lewat, tapi tetap ada kasus-kasus penghilangan paksa yang terjadi di Indonesia. Ada di tahun 2013 Kontras juga mencatat masih ada kasus penghilangan paksa. Di tahun 2019 bahkan ketika masyarakat sipil melakukan aksi besar-besaran saat itu menolak peraturan perundang-undangan yang sedang dibuat oleh pemerintah. Saat itu kami di Kontras menerima ada lebih ratusan pengaduan orang hilang seperti itu, yang kemudian akhirnya kami memerlukan waktu beberapa minggu untuk meng-cross check dan akhirnya satu persatu di mana keberadaan orang-orang ini, begitu. Dan juga tentu saja yang kita tahu bahwa penghilangan paksa masih sampai saat ini terjadi di Papua sana gitu. Juga itu adalah data-data tentang kasus-kasus penghilangan paksa yang terjadi di Indonesia. Nah, sebenarnya pemerintah Indonesia sudah menandatangani konvensi anti penghilangan paksa di tahun 2010. Namun sejak 2010 sampai dengan sekarang pemerintah sama sekali belum pernah menindaklanjutinya ke tingkat ratifikasi. Meskipun waktu tadi Adelwin sudah bilang di UPR 2017 ada kurang lebih 6 negara yang terus menanyakan kepada Indonesia kapan akan meratifikasi, dan pemerintah Indonesia walaupun saat itu mengiyakan gitu ya, tapi sampai saat ini mereka tidak meratifikasi. Nah, di pertengahan tahun ini kita menerima berita baik bahwa Kementerian Hukum dan HAM mau meratifikasi konvensi ini. Dan saat itu dalam audiensi publik yang teman-teman semua bisa akses juga di YouTube Kontras, dia berkomitmen akan sebelum 10 Desember, Hari HAM Internasional 10 Desember 2021, pemerintah Indonesia sudah akan menjadi negara pihak dari konvensi ini. Tapi saat ini sudah menjelang beberapa hari lagi menjelang 10 Desember, kami tahu juga bahwa konvensi ini nampaknya berdasarkan perhitungan gitu ya, nampaknya tidak akan terkejar nih waktunya untuk diratifikasi 10 Desember. Tapi terlepas dari hitung-hitungan waktu dan juga hitung-hitungan berdasarkan situasi politik yang saat ini terjadi di Indonesia, kami mau belajar dan bersiap-siap dari di sini ada dari Sri Lanka, negara yang sudah meratifikasi konvensi anti penghilangan paksa terlebih dahulu gitu. Nah, kami hendak belajar apa yang perlu kami sebagai masyarakat sipil dan juga komunitas korban di Indonesia pantau terkait dengan kalau seandainya pemerintah meratifikasi konvensi penghilangan paksa, apakah ada tantangan ataupun halangan nantinya ketika setelah sudah diratifikasi. Tentu saja ratifikasi ini kan harus diturunkan ke dalam peraturan nasional. Nah, apakah ada dari pembelajaran di Sri Lanka sendiri seperti apa? Apakah ada tantangan atau hambatan dari dalam menerjemahkan konvensi ini ke dalam peraturan nasional, dan juga karena kami negara memiliki hak untuk mereservasi beberapa pasal yang mereka ingin kesampingkan, seperti misalnya di Indonesia dalam konvensi ICCPR, Konvensi Sipil dan Politik, pemerintah Indonesia mereservasi pasal yang berkaitan dengan hak untuk menentukan nasib sendiri. Nah, kami juga membaca bahwa sangat mungkin pemerintah Indonesia akan melakukan hal yang sama, mereservasi pasal-pasal yang penting di dalam konvensi ini. Jadi ada banyak hal yang ada dalam otak kami sebagai masyarakat sipil Indonesia, dan kami ingin belajar dari teman-teman di negara lain. Segitu dulu dari saya, Adelwin, karena kita mau belajar dari negara lain supaya aku nggak terlalu mengambil banyak waktu. Terima kasih.
Oke, terima kasih Kak Preti. Mungkin aku punya satu pertanyaan sedikit sih. Kira-kira dari pemerintah Indonesia sendiri, apakah udah ada upaya belum sih untuk melakukan usaha-usaha reparasi kepada korban-korban penghilangan paksa itu sendiri?
Kalau untuk reparasi terhadap korban penghilangan paksa, pemerintah saat ini sedang menggodok wacana reparasi untuk korban, bukan hanya korban penghilangan paksa, tapi juga korban-korban kasus lain di era otoriter Orde Baru 98 ya, itu. Tapi ini kemudian mungkin nanti akan menjadi satu diskusi lainnya untuk teman-teman yang mendengarkan ini, karena ada banyak permasalahan juga di dalam wacana reparasi yang disampaikan oleh pemerintah ini. Paling pertama adalah tidak melibatkan korban dalam pembahasan reparasi ini. Yang kedua adalah karena ada prinsip-prinsip internasional yang tidak dan juga standar-standar internasional yang tidak dipenuhi oleh pemerintah ketika membuat rancangan reparasi ini. Begitu. Begitu, itu aja dulu, Delwin.
Oke, baik. Terima kasih Kak Preti untuk penjelasannya. Next, let's welcome our next speaker, Ms. Visnavi. The floor is yours.
Hello everyone, can you hear me?
Yes, we can hear you, Ms. Visnavi.
Hello everyone again, and I'm very happy to be a part of this event today. And first of all, I would like to convey my regret on behalf of Mr. Brito, the Director of Families of the Disappeared. He's the one who's supposed to engage in this activity today, but he couldn't make it for some unavoidable reasons. So I am representing the Families of the Disappeared organization in Sri Lanka. I'm a staff of that organization, and my name is Vaishnavi Manogaran. So first of all, I would like to share my presentation on behalf of Brito also. Yeah, before going to detail regarding the International Convention for the Protection of All Persons from Enforced Disappearances, I would like to share the historical events in Sri Lanka, which occurred 20 years, 30 years before, which resulted in thousands of enforced disappearances in Sri Lanka. Basically, Sri Lanka known by the international community for its 40 years to separate internal armed conflict. So the first conflict is happened between the People's Liberation Front, a Sinhalese cumulative group, and we identify that group as JVP, and that conflict occurred between JVP and Sri Lankan government. And the second conflict is occurred between the security forces of Sri Lankan government and the armed group of Tamil opposition group, which we identified as them LTTE. For basically these two internal conflict resulted in various international human rights violations under international human rights law and as well as international humanitarian law. So as a result, Sri Lanka has one of the world highest number of enforced disappearances with a backlog of between 60,000 cases and 1 lakh disappearances occurred since the late 1980s. So because of this history and these events, enforced disappearance occurred in Sri Lanka, and it created many families who lost their family members, and they become a vulnerable community in Sri Lanka. So because of the harmony among the families of the disappeared in Sri Lanka, those families always pushed Sri Lankan government to get the justice for the enforced disappearances, and always they did protest, they did campaign against the Sri Lankan government to ratify the International Convention for the Protection of All Persons from Enforced Disappearances. Always they came to one place, those families came to one place and asked the government for justice for these missing persons. So as the result of those families and the civil organizations who engaged to support those families, the Sri Lankan government signed this convention in December 2015 and ratified it in May 2016. So then when we come to know about the benefits of the convention, and after the convention, Sri Lankan families of the disappeared felt very happy because they thought that they could achieve something. So they thought their protests, their campaigns against the government pushed the government to ratify the convention. So finally, the government ratified the convention. So the families felt happy. That's we find as one benefit. And the second and important benefit is, in order to give legal validity to the convention in Sri Lanka, the Sri Lankan government introduced the Enforce Disappearance Act, which criminalized the enforced disappearances, and it was enacted in March 2018. And this act does not appear to have a retrospective effect. That means people can't ask the government to make cases or to launch complaints regarding the past enforced disappearance which occurred 20 years or 30 years before. But however, the new law give the hope for the people that in future government will not allow the government forces to do this kind of enforced disappearance activities. So this act also gave some kind of confidence to the Sri Lankan families of the disappeared, as well as to the civil society, which engaged to support the Sri Lankan families of the disappeared. So these are the main benefits which we gained from the ratification of the convention. And finally, when we talk about the barriers for the full realization of the ICPPED, the first barrier is will be the reservation under this convention. So Sri Lankan government made reservations under the convention. So the individuals in the Sri Lanka cannot submit their individual complaints regarding the enforced disappearances to the committee which was built up under the convention. So it's a huge barrier to the full realization of the convention. And the second and foremost thing is the attitude of the politician and current government of Sri Lanka. So basically, when we look into the current government and Sri Lankan politician, our president said in a meeting that Sri Lanka didn't have that much enforced disappearances cases. And when we talk about enforced disappearances in Sri Lanka, most of the politicians consider it people saying or speaking against the government or against the military. So the politician and government is not that much support to ratify use the convention and use the mechanisms under the convention as well. So other thing is the attitude of the government authorities. Government authorities means the police, and we have another office called Office of the Missing Persons, which help the families to launch complaints and the families to move forward. So that kind of authorities are in Sri Lanka, but the government authorities and the staffs also not supportive to the Sri Lankan families of the disappeared. So that kind of attitude of the government authorities also a barrier for the full realization of this convention. And the other thing is the unawareness of the families of the disappeared. The thing is, still many families of the disappeared don't know the full concept or full things in the convention. So I think people should know more about this convention, and only it will help to realize the benefits from the convention. So these kind of the barriers are we face in Sri Lanka. And as a civil society and a non-governmental organization, the families of the disappeared us what do is we are currently creating awareness among the families of the disappeared related to the convention, and the international mechanism are available for the enforced disappearance victims. So and also we always support for the families to use this convention for their benefit. So that's how we are handling these barriers, and the attitude of the politicians and current government is not in our hand. We always push them to realize these convention, and always still we are doing campaigns and protests, and also we are writing so much of petitions to the government and foreign embassies, and as well as the UN mechanism to support the families of the disappeared. So this is the way we handle these barriers. Yeah, that's my presentation. Thank you. And if you have any question, you can ask me. Yeah.
Okay. Thank you for your information. Sorry, Miss, how do I pronounce your name? Sorry if I pronounce your name wrong.
My name is Vaishnavi. You can call me Vaish.
Vice. Okay, Miss Vice. I actually have one question for you. So, how is the campaign carried out by civil society organizations in Sri Lanka there to urge the ratification of the convention? What strategy did the civil society organization there use? Because in Indonesia, there have been many campaigns here, but our government has not ratified the convention.
Yeah, basically, we have two communities who faced enforced disappearance in Sri Lanka. One is majority community. Sinhalese also faced the enforced disappearance issues, and also the minority Tamil people. And first, we created peace among those community. Because before that, they two communities didn't aware of the problems among those communities. So first of all, as civil society organization, we created a platform to those two communities to come together and talk and share their problem. First, they came together and they shared their problem. Then the enforced disappearance, families of the enforced disappearance was expanded. And then we started to pressure the government as a civil society organization. And also, I would like to say that some government officials in the office called Office of the Missing Persons and other some officers of the government organizations also supported us. That also a huge, how can I say, it's a huge support for us. So we also used their support, and also we expanded the families of the disappeared. So it made easy us to move towards pressuring the government. Yeah. Thank you.
Okay, thank you, Ms. Vice, for the explanation about the situation in Sri Lanka after the ratification of the. Okay, next we will welcome our last speaker, Ms. Milicia. Hello, Ms. Milicia.
Hello. Thank you.
Okay. Do I pronounce your name right?
Actually, my name is Milica Kolakovic-Bojovic. I'm fully aware it is not so easy to pronounce it properly, but please don't mind.
Okay, thank you. All right, Ms. Milicia, the floor is yours.
Thank you, Mr. Ambar. Very good morning from Belgrade. And it's my pleasure to take part in this webinar because we as a committee members, we recognize the importance of the ratification processes, especially in your respective region, where still there are just a few ratifications. Let me briefly introduce myself, and I will try to speak briefly because we are already running out of time. So I'm a member of the committee since 2017, and since 2019 I'm also the vice president of the committee. Beyond that, I'm a senior research fellow in the Institute of Criminological and Sociological Research in Belgrade. First of all, I would like to share with you some of my impressions that the issue of the ratification of the international treaties in general, including this convention, is being frequently wrongly interpreted or presented in the public discourse like issue of the procedure or issue of overtaking the large scale of obligations for the states. But somehow the most important thing and the buzzword that should be connected to the ratification processes is issue of making an impact in reality. And when we are talking about the ratification of this convention, our buzzword and our main goal should be to make an impact on victims of enforced disappearances. So the committee has recently celebrated its 10th anniversary, and the work of the committee in practice has showed that the ratification of the convention and the consequent activities of the committee aimed at efficient implementation of the convention in the state party can actually result in a significant and tangible impact on victims of enforced disappearances in a state party. So the main activities of the committee in terms of overseeing an implementation of the convention goes through the several parallel tracks, namely through the first reviewing of the state parties' reports and follow-ups in order to define concluding observations and to provide clear recommendations to the state party on how to improve implementation of the convention. The second track is actually urgent actions procedure. The third track is individual and interstate communications. And the fourth track is very important track, and that is committee's work on the adoption of the general comments and guidelines directed to support the state parties to implement either some provisions of the convention or even all the provisions of the convention, but when enforced disappearances occurs in some specific context. And I'm glad to inform you that recently the committee rendered decision to start preparation of the very first general comment on the enforced disappearances in the context of migration. So when we are aware of all parallel tracks, it is important to mention that so far only 64 state parties have ratified the convention, and 48 states just signed the convention, while 86 states have not made any action in this regard. Why this is so important? It's very important because the ratification is precondition to implement all the above mentioned protective mechanisms by the committee in the particular state party. Also, it's very important to mention that among the states that already ratified the convention, only 23 states have accepted the competence of the committee to examine individual complaints or interstate communications. So, considering this, I would like to raise your attention to a few examples of good practices directly influenced by the committee's work. The first example is related to the legislative changes in the state parties triggered by the adoption of the concluding observations after the dialogue, constructive dialogue with the state party. For example, in Spain and Mexico, there are comprehensive legislation dedicated to enforce disappearances adopted after adoption of the concluding observations by the committee. Some state parties decided to adopt comprehensive search policies following not only concluding observations, but following the guiding principles for search adopted by the committee in 2019. Namely, my country decided to prepare for adoption a new law on missing persons as a address search for missing persons, but also to ensure support to victims and to their families. In addition to legislative changes, a great impact has been made by the committee through the urgent actions procedure, which resulted in located 107 disappeared persons so far, and 83 of them have been found alive. And I believe that this data don't require additional explanation, since it's not only about more than 100 direct victims of enforced disappearances. It's actually about a few dozen of their family members, relatives, and close persons who suffered from enforced disappearances of their loved ones, and support by the committee, they managed to know about whereabouts of their loved ones. And also, in addition to urgent actions procedure, I would like to mention a decision of the Mexican Supreme Court, which declared the binding character of the urgent actions when it comes to obligation of the state party to implement measures rendered by the committee in relation to making persons safe and to protect their family members. Also, I would like to mention importance of the mechanisms of interstate cooperation triggered by urgent actions in order to, through those cooperation mechanisms, locate and protect victims of enforced disappearances. And finally, there is a very important point when it comes to the role of activists and members of the associations of the families of missing persons, and also about NGOs, activists who are trying to support victims and their families. The committee has a mechanism to react upon reprisals or intimidation against NGOs, activists, and members of association of family members of missing persons. In this regard, it is important to mention that the committee has adopted the guidelines to prevent and to address intimidation and reprisals against individuals and groups cooperating with the committee on its 26th session in April this year, to rule this procedure in detail and to make it more visible for those who need to follow it. And of course, you can find all details about that procedure on the website of the committee. So I don't want to take more time for this initial presentation, but I will be open for all your additional questions or some explanations if needed. Thank you.
Okay, thanks, Ms. Milika, for your explanation. Next, selanjutnya kita mungkin bisa langsung lanjut ke Pak Payan. Pak Payan, apakah bisa mendengar suara saya?
Saya bisa dengar. Saya udah dengar. Apakah suara saya bisa didengar?
Bisa terdengar, ya. Jadi Pak Payan ini juga salah satu korban penghilangan paksa di Indonesia. Untuk Pak Payan sendiri, aku mau bertanya nih. Jadi pemerintah itu sudah berjanji akan meratifikasi konvensi anti penghilangan paksa ini tanggal 10 Desember, yang sebenarnya waktunya juga sebentar lagi. Tapi juga ada kemungkinan kalau kita melihat itu sebentar lagi, namun pemerintah belum ada melakukan sesuatu hal yang perlu gitu. Mungkin ada kemungkinan tanggal 10 Desember itu juga belum bisa pemerintah meratifikasi konvensi tersebut. Bapak sebagai korban penghilangan paksa, kira-kira bagaimana tanggapan Bapak terhadap tindakan pemerintah?
Ya, terima kasih atas kesempatan diberikan kepada saya untuk memberikan atau menanggapi mengenai akan diratifikasinya konvensi penghilangan paksa. Cuman saya sendiri sebenarnya pernah saya berbicara dengan Pak timbul Sinaga yang di Menkumham, itu katanya memang waktu itu saya bilang ya sudah diserahkan ke Seknek untuk ditandatangani Presiden itu ratifikasinya. Nah, cuma saya tidak tahu urut-urutannya itu setelah ditandatangani Presiden itu kan harus dibawa ke DPR lagi untuk melakukan menyusun undang-undang untuk penghilangan paksa di Indonesia. Nah, itu yang saya agak rancu. Apakah nanti undang-undangnya sendiri yang undang-undang di negara kita itu mengacu kepada ratifikasi itu, apakah kita atau katakanlah kami diberikan kesempatan untuk membaca atau mendengarkan apa saja sih isi daripada undang-undang ratifikasi itu. Karena saya juga tahu apakah nanti kasus-kasus penghilangan paksa yang sebelum ditandatanganinya ratifikasi tersebut, apakah ada dampaknya terhadap penyelesaian kasus-kasus penghilangan paksa yang telah lalu gitu. Dan kira-kira seperti apa agar ratifikasi itu mempunyai kekuatan atau mempunyai semacam dorongan agar kasus-kasus penghilangan paksa tetap diusahakan diselesaikan dengan ditandatanganinya ratifikasi tersebut. Jadi itu yang saya belum tahu persis dampaknya terhadap, kalau misalnya ratifikasi ini telah ditandatangani terus kemudian dibuatkan undang-undangnya, apakah dia akan berdampak berkekuatan untuk menyelesaikan kasus-kasus yang sampai saat ini belum terselesaikan. Misalnya ya paling tidak untuk penghilangan paksa 9798 di mana DPR telah memberikan rekomendasi kepada pemerintah untuk segera menandatangani ratifikasi tersebut, tetapi kan ada poin-poin yang lain yaitu mencari orang yang hilang, terus kemudian melakukan membuat pengadilan HAM ad hoc misalnya gitu. Kira-kira ada nggak poin-poin itu di ratifikasi itu gitu kira-kira? Karena saya tidak tahu persis seperti apa nanti setelah ditandatangani terus apa dampaknya terhadap kasus-kasus penghilangan paksa atau pelanggaran HAM berat masa lalu. Kira-kira itu yang bisa saya saya pertanyakan terlebih dahulu. Terima kasih.
Baik, terima kasih Pak Payan. Mungkin juga emang kita punya banyak pertanyaan nih kepada pemerintah. Bagaimana prosesnya dan juga bagaimana efek-efek ke depannya. Ya, sayangnya juga dari pihak Kementerian Hukum dan HAM dan juga dari DPR sendiri tidak bisa datang ke acara kita hari ini. Sangat disayangkan, padahal kita punya banyak pertanyaan. Dan berharapnya ke depannya mungkin nanti bakal ada sosialisasi lagi dari pemerintah bagaimana efek ratifikasi ini, dari ratifikasi konvensi ini. Baik, mungkin dari Kapreti atau mungkin dari speaker lain, apakah ada tanggapan terhadap pertanyaan Pak Payan? Tanggapan Pak Payan, mungkin kita silakan dari Kapreti dulu mungkin.
Boleh. Aku Adelwin. Mungkin nanti yang pertanyaan Papa yang pertama yang berkaitan dengan apakah sebenarnya yang Papa yang mau tanyakan kan apakah ada apa sih keuntungannya ratifikasi konvensi ini bagi korban untuk kasus-kasus yang sudah terjadi sebelum negara meratifikasi konvensi ini gitu. Nah mungkin aku Adelwin mungkin itu lebih tepat nanti karena udah ada expertnya juga di sini nanti lebih ditanyakan kepada Miss Milica mungkin nanti bisa. Tapi untuk menjawab pertanyaan Papa yang lain berkaitan dengan ratifikasi konvensi ini, betul Pak Payan bahwa ini masih memerlukan masih memerlukan lagi RUU-nya, naskah RUU-nya diserahkan ke DPR gitu. Nah, sampai sekarang baru nanti kemudian ketika sudah diserahkan ke DPR ada pembahasan, baru kemudian nanti disahkan di sana. Tapi sampai saat ini ratifikasinya sampai saat ini belum masuk naskah RUU-nya ke DPR gitu. Jadi DPR belum ada membahas itu gitu. Jadi masih ada kira-kira 2 proses lagi yang harus tahap lagi yang masih harus dilewati, yaitu 1 surat presiden nanti kepada DPR, dan yang kedua pembahasan di DPR baru konvensi ini bisa diratifikasi gitu. Nah, berkaitan dengan isi konvensinya, Papayan nanti kita bisa kita kontakkan, akan nanti kita kasih konvensinya yang sudah diterjemahkan ke bahasa Indonesia, jadi nanti lebih mudah untuk dibaca. Nanti aku akan kontak Papayan. Tapi untuk apakah tadi yang pertanyaan Papayan yang pertama dan paling utama itu tadi, aku juga penasaran dan mungkin lebih baik ditanyakan kepada langsung dari dari Komite Penghilangan Paksa PBB-nya, Adelwin.
Terima kasih Kak Reti. So Miss Midisha or Miss Vice, if you want to respond to Mr. Payan's question, you can respond it right now.
First of all, thank you for your question. If you look at the Article 2 of the Convention, you can see that the crime of enforced disappearance, according to the Convention, is continuous crime. What does it mean? It means that the crime of enforced disappearance is over, it's finished, when the fate and whereabouts of the missing person are known. So until that, there is the obligation of the state to search for the enforced disappeared person, to investigate the case, and to provide reparation to the family members of the victims. So until the end of that process, there is the obligation of the state to investigate even cases of enforced disappearances started prior to the ratification of the convention, but still ongoing in the moment of the ratification. So if you ask about cases from 20 or 30 or 40 years ago, where the fate and whereabouts of a person are still not known, yes, there is an obligation of the state to search for a missing person. There is an obligation of the state to investigate those cases, to report to the committee about the progress of investigation, and to report to the committee about measures taken to ensure reparation mechanisms for the family members of those victims. Thank you.
Okay, thanks, Ms. Milica, for your response. Ms. Vice, is there any response for Mr. Payan's questions?
Yeah, in Sri Lanka, the Enforce Disappearance Act bill was placed in the parliament in 2017, and the act was enacted in 2018. So it took 1 year for us to enact the Enforce Disappearance Act in Sri Lanka. So basically, the thing is, we always want to give pressure to the government. We always want to make the government to think about the enforced disappearance issues. In Sri Lanka also, we don't have any enforced disappearance issues currently. But the families who miss their relatives 20 years or 30 years before, So still they are campaigning, they are engaging in activities to give pressure to government. So I would like to say that the families should always be aware of the activities of government related to these enforced disappearance issue, and always they want to build a relationship with other families, and they always want to give pressure to the government. Then only the government will realize that the families still want to ratify the convention or enact the act related to the enforced disappearances. Yeah, thank you.
Okay, thank you, Ms. Faiz, for your response. Okay, next, we will enter a question and answer sessions between the audience and speaker. And we already have some questions from YouTube comment section. Okay, so for Miss Milicia, there are three questions for you. So number one is in which articles in the conventions are most reserved by the ratifying country? Number two, if the most reserves is the Committee on Enforced Disappearance, Article 26, besides the individual mechanisms that have been accessible to working group, what can civil society organizations do regarding the UN mechanism to monitor the implementation of the conventions? And number three, can the conventions be appealed to cases that occur before the ratifications by? Okay, Ms. Mika, do you want to answer the questions now?
Yes, of course. I've already answered some of those questions. When it comes to reservations, the most reservations related to Articles 31 and 32 of the Convention. Of course, you already know that Article 31 refers to individual communications to the committee, and in accordance with Article 31 of the Convention, any individual claiming to be victim of a violation of the rights protected under the Convention can submit a complaint, also called communication, to the committee, and the individual communication procedure only applies to state parties that have made a declaration to accept the competence of the committee to examine individual complaints under Article 31. And this declaration can be made by the state party when becoming a party of the convention or at any time afterwards. So this is very important to know, because the fact that the state party has not initially accepted competence of the committee under Article 31 doesn't mean that supported by NGOs and Association of the Victims of Family Members, and also through the public campaign, cannot be made impact in that state party to accept competence of the committee under Article 31. Also, when it comes Article 32, frequently state parties are not willing to accept competence of the committee under interstate communication. Interstate communication procedure allow for state parties to complain to the relevant treaty body, in this case to the Committee on Enforced Disappearances, about alleged violations of the treaty by another state party. As I mentioned earlier, only 23 state parties accepted competence of the committee under the Articles 31 and 32. When it comes to the role of NGOs, from the standpoint of the committee, NGOs have a very important role during the process of analyzing reports of the state parties during the process of the constructive dialogue with the state party, but also after publishing concluding observations, because a report submitted by NGOs who are following the situation in state party are very important for the committee to have a clear picture what's happening in the field, and to have a clear picture about the current status of implementation of the recommendations of the committee. And when it comes to the competence of the committee, to monitor implementation of the convention regarding the enforced disappearances occurred prior to ratification, I believe that I already answered that question during the prior set of questions. Thank you.
Okay, thank you, Ms. Misha, for the answer for the questions. We also have one question for Ms. Vice. Ms. Vice, from the YouTube comment sections. Ms. Vice, is there any articles in the conventions reserved by Sri Lankan government?
Yeah, as earlier Minika mentioned that there is an article to individual complaints. So Sri Lankan government have a reservation on that individual complaint article. So individual of Sri Lankan enforced disappearance victims can't submit individual communication to the enforced disappearance committee. So that's the reservation from Sri Lanka. I think you are muted.
Sorry. Okay, we have one more question for Ms. Vice. So, if Sri Lanka reserve articles on individual complaint, what can civil society organizations do in Sri Lanka to make realization of the articles?
Yeah, basically, Sri Lankan civil society organizations such as Families of the Disappeared, we submit our communication to the working group of UN working group on enforced disappearances. It also a mechanism which was set up by UN. So we submit our complaints to the UN working group of enforced disappearances, and that working group come across that complaints, and they communicate those enforced disappearances cases to the Sri Lankan government. So that's how we handle this issue.
Okay, thank you, Ms. Vice, for your answer. We also have one more question for Ms. Milicia. So, is there any communications between Committee on Enforced Disappearance and the government of Indonesia regarding the ratification of the conventions? What is their response to the communication? If there is communications between the committee and the government?
Unfortunately, that is the question that cannot be answered by myself, because the role of the committee members of the committee actually starts from the moment of the ratification. We as members of the committee, we are not aware of the political part, let's say diplomatic part of the processes when it comes to ratification. But what I can say is that we are committee members are really dedicated to fostering ratification processes around the world, especially in your region, because we need to go through the process of universal ratification, because enforced disappearances are serious crimes occurring around the world from day to day. That is not crime which is typical for a particular region or particular period. We should be aware of the different contexts around the world which triggering enforced disappearances. So please be aware of the role of the committee members as experts. We are not representatives of our respective countries. We are not aware of diplomatic processes or political processes, but we are only experts dedicated to reviewing and monitoring implementation processes in the state parties, but we are also on dispose for all state parties, but also for states that are considering ratification of the convention, to explain importance of the convention and also to support the state parties when there is a need to organize awareness raising campaigns or training in the states to raise awareness not only of the stakeholders and decision makers, but also awareness of the professionals and NGOs about importance of this convention.
Okay, thank you, Ms. Mishka. Actually, we have one more question for Ms. Milicia. It's about the interpretation of enforced disappearance. Can mass arrest without notification to family or lawyers be called enforced disappearance? Although a few days later, the victim was finally found at the police station or other places.
Can you please repeat your question? Because
okay.
quality sound is not really good.
Okay, so can mass arrest without notification to family or lawyers be called enforced disappearance? Although a few days later, the victim was finally found at the police station.
Yeah, to constitute the crime of enforced disappearances, there is a need of existence of a few basic elements. So, enforced disappearances is considered to be any kind of arrest or detention or abduction or any other form of deprivation of liberty by agents of the state or by persons or groups of persons acting with the authorization, support, or acquiescence of the state. And the final element, following by a refusal to acknowledge the deprivation of the liberty or by concealment of the fate or whereabouts about disappeared person, which place such a person outside of the protection of the law. So when there are all of those elements present, we can say that there is a crime of enforced disappearance.
All right, thank you for your answer. We have one question for every speaker, for all speakers. So, what is the ideal mechanism to fulfill the right to truth for the enforced disappearance victims? Because in Indonesia, in Indonesian political context, judicial process is de facto stuck, and the non-judicial mechanisms such as truth commission and reconciliation or commission of inquiry, according to the experience in some countries, is always potentially could be another measure to strengthen unity. Mungkin untuk Kak Preti bisa menjawabnya duluan.
Sorry, Anil, boleh diulang pertanyaannya? Tadi putus-putus.
Oke, jadi pertanyaan ini ditujukan kepada semua pembicara. Bagaimana mekanisme yang ideal untuk menegakkan hak atas kebenaran bagi korban penggalan paksa Sebab di Indonesia, proses hukum secara de facto benar-benar mangkrak. Dan di sisi lain, mekanisme non-yudisial seperti Komisi Kebenaran dan Rekonsiliasi dari beberapa pengalaman negara lain senantiasa berpotensi menjadi cara lain untuk melanggengkan impunitas.
Baik, dari konteks Indonesianya, sebenarnya ini udah ada ya di dalam salah satu dari 4 rekomendasi Pansus DPR yang tadi Pak Payan sudah sebutkan tadi di awal, terkait dengan, jadi ada rekomendasi dari Pansus DPR 2009 kepada Presiden dan jajarannya untuk mencari keberadaan orang hilang. Nah, kalau misalnya kita belajar dari pengalaman yang sudah ada, pengalamannya dalam artian laporan yang sudah ada, rekomendasi yang sudah ada, karena aslinya rekomendasi ini juga tidak ditindaklanjuti oleh pemerintah. Jadi dari pengalaman Indonesia ada hasil rekomendasi waktu itu untuk kasus pencari kebenaran untuk kasus Timor Leste. Di situ sudah dibilang bahwa pemerintah harus membentuk komisi untuk orang hilang, bukan kontras ya, kontras masyarakat sipil, tapi semacam kontras dalam artian semacam komisi untuk orang hilang yang dibuat oleh pemerintah, yang secara formal tujuan mereka memang adalah mencari keberadaan orang-orang ini gitu. Apakah orang-orang ini kalau misalnya dalam kasus Timor Leste kan anak-anak itu masih hidup ada di Indonesia, dan ini harus dicari dan dipertemukan kembali dengan keluarganya yang ada di Timor Leste. Untuk kasus-kasus penghilangan paksa yang lain dicari kemana keberadaannya, sehingga nanti keluarga korban bisa mendapatkan kepastian apakah anaknya, apakah keluarganya yang hilang itu masih hidup. Kalau masih hidup ditunjukkan di mana, atau sudah mati gitu. Kalau misalnya sudah mati, tunjukkan di mana kuburannya atau mayatnya, atau dibuang kemana gitu. Nah, jadi itu sebenarnya udah ada di dalam sejarah laporan yang menjadi PR pemerintah untuk dibuat sebenarnya gitu. Tapi sayangnya sampai sekarang baik untuk kasus Timor yang sudah ada rekomendasinya, baik untuk kasus penghilangan fakta 9798 yang juga udah ada rekomendasinya, dua-duanya sama-sama masih belum dibentuk komisi ini gitu. Jadi untuk penghilangan paksa, walaupun misalnya KKR kan kaitannya sama amnesti dan segala macam. Sebenarnya kita harus membentuk tuh komisi untuk orang hilang dan komisi yang mencari orang hilang gitu. Nanti kita bisa belajar dari selanjutnya, nanti pasti akan dilanjutkan oleh teman-teman dari internasional bagaimana pengalamannya di internasional, karena juga ada misalnya CONADEP di Argentina yang misalnya sampai menggunakan DNA untuk mencari keluarga yang hilang itu ada di mana gitu. Dari aku, Adel.
Terima kasih Kak Preti. Ms. Vice, you can answer the question.
Yes, I would like to answer from the Sri Lankan perspective. And in Sri Lankan government also said that it will build up a truth commission. So still the process is going on, and we still haven't a proper truth commission in Sri Lanka. In the past, Sri Lankan government appointed many commissions to inquire regarding the enforced disappearances, such as a presidential commission on enforced disappearances. So these kinds of commission also inquired the families, and also as the recommendation in their report, they mentioned that Sri Lanka should have a truth commission. So still we are struggling to set up a truth commission in Sri Lanka. That is the truth, because we don't have that much support from the current government as well as the politicians to set up the truth commission. But in Sri Lanka, we have a office called Office of the Missing Persons. So currently, Sri Lankan families are rely on that specific office. I don't know whether Indonesia has that kind of office in your country, but in Sri Lanka, we have a specific office called Office of Missing Person. So until the setup of the Truth Commission, Sri Lanka families of the enforced disappearance are going to that particular missing office, and they are communicate with those officers. But I'm sad to tell that still Sri Lanka also struggling to build up a proper truth commission here. Yeah, thank you.
Thank you, Ms. Faiz, for your answer. Next, Ms. Amisha, you can answer the question. Hello, Ms. Midisha.
Can you hear me?
Yes, we can hear you.
Yeah, the connection is not very good currently, but I believe that you can hear me. When it comes to comparative experiences, I can say that the best model is the model which makes an impact in practice. What does it mean? This means that there are very good examples in the comparative law that where the state parties decided to establish kind of truth commissions. Some of those commissions are in charge only to coordinate investigation and search processes. Some of those commissions are not in charge of investigation processes, but rather for reparation processes to ensure effective support to the family members of the missing persons. But if we are talking about necessity to establish the Truth Commission, I can say that there is no always need to establish that kind of commission if in practice there are mechanisms to ensure independent and impartial investigation within the, let's say, standard system of law enforcement and judiciary. If those mechanisms are fully functional, fully independent, fully impartial, I believe that there is a possibility to ensure proper implementation of the convention without establishing special commission. But sometimes there is a need to establish that kind of commission to improve coordination processes between police and prosecution service and judiciary, and also to establish some additional mechanisms, especially additional mechanisms related to support to victims to family members. Sometimes there is a need to have that such a body to coordinate support services when it comes to a need to establish a nationwide network of support services. And also you should be aware that there is an important role of NGOs when it comes to reparation mechanisms. So sometimes that kind of truth commission could be a good solution to ensure proper coordination and cooperation between the state institutions and NGOs to ensure the greatest possible impact when it comes to benefits for victims and their family members.
Okay, thank you, Ms. Misha. Actually, there is one last question for you. Is it all right, Ms. Misha? Okay, Miss Manisha. So it's actually we have one last questions for you. So the definition of a victim has been explained in the convention ICPPED, but actually, how many generations of a family can still be called a victim based on the definitions in ICPPED?
According to the Articles 24 and 25 of the Convention, any person who suffered from enforced disappearance should be considered as a victim. So it's not only about persons who are direct victims of enforced disappearances, but also family members and other close persons of victims, direct victims of enforced disappearances, are considered to be victims of enforced disappearances according to the convention, and they all should have access to compensation, to proper compensation, to psychological support, health services, and also they should be free to establish associations to fight for rights of their family members who disappeared. Thank you.
All right. Thank you, Ms. Manisha, and thank you for all the speakers for your questions to these questions. We have reached the end of the webinar. So let me summarize our discussion today. From Ms. Pretty, she has explained that there are many cases of enforced disappearance happen in Indonesia. For the example, Tangsari, in East Timor, and many more. Although the authoritarian regime has ended, Indonesian regulations have not fulfilled the elements of enforced disappearance. Contrast as civil society organization has received many complaints of missing persons. Indonesia has signed the ICPPED but has not followed up until the level of ratification. Our Ministry of Law and Human Rights wants to ratify the convention, but until now, before December 10th of 2021, there are still no update about the ratifications. From Ms. Vice of for a family of forced disappearance in Sri Lanka, she explained that Sri Lanka has a high number of victims of enforced disappearance. And Sri Lanka has ratified ICPPED in May 2006. The benefits of ratification are psychological benefits for the victims, such as confidence. Although there is no retroactive effect, at least there is a guarantee that there will be no enforced disappearance happen in the future. Unfortunately, there are some reservations to the convention, such as no individual complaints, there is also the attitude of the politicians and government regarding the ratification of the convention and the lack of awareness of family of enforced disappearance. We also have explanation from Ms. Milisha from Committee on Enforced Disappearance. So the ratification is one of the protective measures of the state party. It is necessary to take into account the best practice for this convention. For example, in Spain and Mexico, there is comprehensive legislation dealing with enforced disappearance. Besides, to ensure the support for the victims, in addition, we need to support the legislature to urge the ratification of the convention. So thank you for all the speakers and attendees for attending the webinar. I sorry for any inconvenience. I hope this webinar will be useful in the future in understanding the ratification and the benefits for Indonesia and other countries regarding the Convention on Enforced Disappearance. Thank you.